It is a common occurrence for one sibling to say to another at any of the smallest petty disagreements, "Okay, if you don't like it, sue me," because any sibling that did bring a lawsuit would be automatically disinherited. The primary goal of having alternative dispute resolution, or ADR, is to resolve conflicts after you and your spouse have passed away, presumably amongst your kids or grandkids. There are many different methods of alternative dispute resolution to try and help resolve conflicts while maintaining family relationships and avoiding the cost and time associated with a full court litigation. The primary method that we use for our clients is what we like to call the integrity agreement. One of the primary differences between the integrity agreement and most other ADR tools that are on the market is that we have the integrity agreement as its own document with a detailed outline of how to resolve conflict through communication, negotiation, mediation, and arbitration. We try to resolve these conflicts at the earliest possible stage. If it's not capable at level 1, we will bring it up to level 2 to resolve at that level. The first method is communication. Can the parties who have a disagreement actually communicate to each other what the disagreement is and see if it can be resolved from that? Often, people will have a disagreement but haven't properly communicated that to the party that is causing it, and therefore, nothing can be fixed because the party who's causing it doesn't realize what it is they are causing. To illustrate the methods in which the integrity agreement can resolve conflicts, we're going to use the example of two kids in a family who are both trying to use a bike that the family owns. In communication, if the kid who is currently using the bike wants to keep using the bike, but doesn't know that the other kid who is not using the bike wants to have a turn with it, the mere communication that they want to take a turn on the family bike might resolve the conflict, because the kid who is riding the bike might be willing to take a turn not riding it for a time. If the communication method is able to resolve the conflict, then we don't need to go to the further methods laid out in the integrity agreement. We've resolved it and we can move on. If, however, mere communication of what the issue is between party A and party B does not resolve the conflict, then we can go on to method 2 of the integrity agreement. The second method of the integrity agreement is negotiation. Can the two parties sit in a room together and hash out what the disagreement is and what would resolve it? Negotiation is most often perceived as something that only happens between business parties, but this happens in families quite regularly. If two kids are fighting about who has the right to use a bike that is the communal family property, they are negotiating about the time each kid deserves on the bike and when it is transitioned from one kid to the other. Often, negotiations, particularly between siblings, are able to be resolved without any further methods of conflict resolution being required. If, however, the negotiation method is unable to resolve the conflict between the parties, then you go to the third method of conflict resolution. The third method is mediation. This is when a third party is brought in to hear both sides of the disagreement and try and help them sort out where the issues lie and what might resolve their conflict. The most common circumstance for mediation to be used is in divorce. Family law courts often, as a matter of practice, require that a couple who is getting divorced go through mediation first. The goal is that as little court time as possible will be used to resolve the dissolution of the marriage, and as many things as the couple is able to sort out on their own with the help of a third-party mediator, the better. To go back to our example of kids using a bike, if the two kids are not able to resolve the conflict of how and when they are each to take turns using the family bike, they can bring this disagreement to a parent or another third party to act as the mediator between them. As the mediator, the parent can hear both kids' sides and help them decide how and when they ought to take turns. In a mediation, the mediator helps the parties come to a resolution that they agree upon amongst themselves and by themselves. In the integrity agreement, the fourth method of resolving conflict is called arbitration. In an arbitration, a third party is brought in to hear both sides of the disagreement and then to come up with a resolution. One of the primary differences between a mediation and an arbitration is that in a mediation, it is still the parties themselves who resolve the conflict, whereas in an arbitration, the arbiter would resolve the conflict on behalf of the parties and enforce it, regardless of whether it was the resolution that each party individually had in mind. There are many different methods of having an arbitration. In a family, often the parents will act as either mediators or sometimes arbitrators between their children when the children have disputes amongst themselves. If the two kids who both want to have a turn on the bike are unable to resolve the conflict amongst themselves, the parent may decide at what point is each individual kid going to have a turn on the bike and for how long. Or in some cases, the parent will just take away the bike and no one gets a turn. While not everyone is truly familiar with the ins and outs of all alternative dispute resolution methods, there are many methods that are more familiar to you than you know by default. People have intuitively found ways of resolving conflicts amongst themselves and between themselves and other parties. As such, the integrity agreement is designed to just write out, here are the methods and how they will be measured, so that if the conflict would otherwise result in court, we can avoid a court or litigation process and costs that are involved in a full-blown litigation. In many estate plans, people will have language that automatically disinherits any beneficiary who attempts to get a bigger piece of the pie by suing the other beneficiaries or the estate. We utilize the integrity agreement to have a similar effect. Any beneficiary of a trust or a will that has the integrity agreement built into it will be automatically disinherited so long as they pursue the court-based litigation. One example of an integrity agreement being used in practice is a client who had 4 children. After the client had passed, one of the children decided that they wanted to sue the other children in an attempt to get more than just 1/4 of the estate. As the attorneys for the estate, we informed this beneficiary that if they were to pursue an actual court litigation, that they would be automatically disinherited. They chose to ignore this warning and go forward with a lawsuit against their siblings. At the conclusion of the lawsuit, the one child who was suing their siblings was rightly informed that because they had sued, they get nothing from the estate. Upon realizing that our warning prior to the lawsuit going forward was accurate, this child decided that they wanted to reconcile with the other beneficiaries in an effort to get something that they would have otherwise received had they not sued the family. The other beneficiaries then had a meeting amongst themselves to discuss whether they were willing to forgive the beneficiary who had gone through with a lawsuit against the rest of them. The beneficiaries decided that so long as the one sibling who had brought forth the lawsuit against the rest of them was willing to pay all of the associated attorney's fees in regard to the litigation, that they would be reinstated to receive what was left of their 1/4 share of the estate. This resulted in the relationships between the 4 siblings being more strained than they would have otherwise been. However, they were able to reconcile after the litigation had been commenced. The relationships were repaired to some extent after things had been resolved, because the one party who had brought the disagreement to the court and a full lawsuit bore the primary cost for taking that course of action, even though it was not in standing with the estate itself. This full set of circumstances regarding this lawsuit could have been avoided had each of the beneficiaries acknowledged the method set forth in the integrity agreement for resolving conflict with the estate. With the fact that the integrity agreement is fully integrated and utilized in my parents' estate, it is a common occurrence for one sibling to say to another at any of the smallest petty disagreements, "Okay, if you don't like it, sue me." And this will always result in a further communication as to how to resolve the conflict without going to that ultimate means. We are able to have lighthearted jokes about the possibility of a lawsuit, knowing that a lawsuit isn't going to come about, because any sibling that did bring a lawsuit would be automatically disinherited. We welcome your thoughts. In order to help us improve future videos, please leave your comments below. If you want to learn more about how the law can help protect your family and wealth, please visit our website and subscribe to our channel to watch more of our videos. Our firm is taking on new clients. If you want to work with us, the best way to get on the waitlist is to click the link below. We look forward to hearing